Welcome this evening. My name's Kim Pride, for those of you that don't know me. I'm the President of the Planning Institute in South Australia, and I'm going to be facilitating the session today till about 6:15, and then Emma's going to take over 6:20 because I've got to rush home and collect my kids before my partner goes off to work. Just a quick reminder, because we're talking about accredited professionals and getting CPD points today amongst other things. If you haven't signed in at the door, you don't get your points. That's the way it works. We don't know that you're here unless you sign in, so if you want them, sign in. Now today's really a bit about a session that PIA and DIPTI have combined to bring to planners within the community of South Australia, just to talk about some of the myths that we're hearing around the place, around the reforms, accredited professionals and the code in particular. I get a lot of people approaching me and asking me different things, hearing different things, and of course, you know, with all change, there's a bit of a rumour mill happening. So we thought, why not do a myth-busting session? We've got Anita just to talk a little bit and set the scene, but really this session is for you to ask questions of us, the things that you've heard and that you want to clarify about the reforms going forward. So with that, I'll ask Anita to come up and set the scene. Anita Allen, everyone.
So today I thought I'd speak to you briefly about what's happening in planning reform, the latest update, some of the key changes in our development assessment scheme and accredited professional scheme and how they connect together, and also provide you with a bit of an update on the planning and design code and how we're supporting practitioners in the new system. So the last few months have been extremely busy for the department, and also for many of you out there who's put many precious hours into writing submissions for us on a number of key things. The accreditation scheme has been an important part of that, as have the general regulations, which I appreciate are over 300 pages of regulations, which we did receive some very important submissions on. And I'll touch on what some of those submissions said in a minute and how we might respond to some of those things. We also had the Phase 1 code, so the first code for the outback areas, where we also received a whole suite of submissions. And I'll also touch on that with you today, what we heard and what we're doing as our next steps. We also have building inspection policies. I know this is more of a planning crowd, but for those who have any connection with building or in local government, you might like to encourage your colleagues to make some comments on the building inspection, sorry, not inspections, the ministerial building standards. I've got it written down wrong here. Building inspection policies will be coming out soon. So one of the things I did want to encourage you to do is be curious. When anything new is coming about, it's easy to have these questions that come into your mind and to talk to them sometimes with your colleagues. But it's also useful to come and make sure that you have the right information. So if you have any questions, please go to our website. We're trying to keep that really up to date with Q&As. So when we receive questions from any of you out there, we do capture those questions and put responses up there on the SA Planning portal. We also have a dedicated email address, so if you have any questions, you can email them to our engagement team, and we will respond to you as quickly as we can, and then we use those answers to once again update our planning portal with any responses, so everyone gets the same information at the same time. If you are in local government, we also encourage you to use our Council Connect. So, as you all know, the recent general regulations set out a whole suite of changes to the way we will do development assessment in South Australia. When you look at those regulations, you would have found that a lot of it is familiar. So there's probably about 60 to 70% of it that's quite similar to the process that we undertake now under the Development Act 1993. A lot of it has been update to terminology and language, but also opportunities to streamline the assessment process, particularly as it relates to the e-planning solution. So by bringing in an e-planning solution, it does change the way we start to think about development assessment. No longer will paper-based applications be received on your desk, and you'll need to filter those through administrative procedures and work out where they sit. These will all now start to come in through a simple central lodgement system that will allocate applications out to the relevant authority. So I'll speak to you a little bit more about what that might mean for you soon. So the new system seeks to streamline simple and expected development types, so simplify the applications that should be dealt with quickly and are quite straightforward, and put the time and effort into those applications that are more complex and need a bit more time for the assessment process. We also have for the first time the sign on land, and I know there have been a lot of questions raised about how the sign on land can be created and provided on the land itself. The technical questions about what if somebody removes that sign, whose responsibility is it, and there's a whole range of questions like that which I'll touch on a bit further. But the intention is to provide greater transparency to the community. And just coming back from the UK, you can see that signs on lands are very common. As you go through the UK, signs on land are everywhere. And in fact, they're quite simple notices that as you walk past a piece of land, you can see the notice, you go, oh, a development's happening in that area. If I'm interested, I walk up to the sign, I find some more information, and I can go online to find out more about the application. So as complex as it can appear, it can actually be quite a simple thing, and I think that's where we need to take it. It does provide greater transparency, and the community's expectations about the availability of information in relation to development applications is undoubtedly increasing. And we need to move with that and find out how we balance the needs for the community to understand what's happening in their area and balance that with the rights of applicants to have their application appropriately assessed. So there will be more. At the moment, our development assessment system has complying development, which is similar to our new deemed to satisfy applications. We all know that there is a limited amount of complying development in most development plans in South Australia, and the residential code was an opportunity to start to improve and increase the amount of deemed to satisfy or complying development across the state. Was it perfect? Some would say yes, some would say no, but there's always room for improvement for anything like that. The other thing that's really quite new to people is deemed approvals, and we receive a lot of questions about deemed approvals and how they work all the time. But essentially it means that if an application is out of time, the applicant can seek a deemed approval and then it can be considered by the courts. We also have the new development assessment process. Now we tend to use this term called DAP. And I know for some people that's a bit confusing because we think of that as the development assessment panel. But this is the development assessment processing system that we have. Now I think most of you know this, so I won't go into this too much other than to say there are changes in terminology, particularly around exempt development. Accepted development is no planning consent required. We've got code assessed, which has two types of development assessment within it. One is deemed to satisfy, which we've already mentioned, and the other is performance assessed. Impact assessed development has three types of categories. The first one being restricted, which is set out in the Planning and Design Code. And the State Planning Commission is the planning authority for all forms of restricted development. For impact assessed, it can be set by the regulations, and that's akin to a major developments assessment process. And then we have impact assessed, which is declared by the Minister. So that's in a more ad hoc way. Projects can be called in. So some of the feedback that we received on those on the development regulations were around timeframes. So this probably won't surprise you too much, but local government generally said that the timeframes weren't long enough, and the development sector said the timeframes were too long. So where we think we've probably landed somewhere in the middle, which isn't too bad. We have had regard to the fact that there are deemed approvals, so the timeframes do need to be appropriate and reasonable that you can actually undertake the assessment task. We also heard a lot of commentary around verification. So when an application comes in through the SA Planning portal, the authority needs to verify that application. So that's to make sure that it has been properly made, so it has all the parts to an application that it requires. And that it is in fact the type of application the applicant has said that it is. For example, they've lodged it as a performance assessed and it turns out it's deemed to satisfy, or they've said it's deemed to satisfy, it turns out to be performance assessed. Now one of the key comments we did receive around that was that people were concerned that to determine that it's deemed to satisfy, you in fact have to assess it. So that's been something that we've taken on board, and we think that we were able to resolve that through the regulations and make that a lot of a simpler process. But in terms of the legal decision about what the application is, that's always going to be up to the relevant authority. The other question we got that came to us a lot was about relevant authorities. So in this Act it's quite different. Previously the Act used to require that the council was essentially authority and the council delegated to a development assessment panel, or they could delegate to staff within the council. this Act is quite specific in that it sets up the scheme for different types of authorities. So if the regulations say that the Council Assessment Panel is the authority, then that is the case. That authority may delegate down to other bodies that it sees fit. And the Assessment Manager is the other authority often within the Council, and they once again may delegate down. The feedback that we received was that too much was going to development assessment panels, and that was pretty consistent. We received that message from both local government and the private sector. So we are looking at that, and I'll show you that where we're going in a moment. Once again, sign on land, too complex. So we are looking at simplifying that so we can just do an A3 sign on the land that most councils could print off in their office, laminate and stick up without too much effort. So I think where the sign was going was getting a bit too complex and costly to start delivering. So we're happy to try this out and see how it works. It's one of those things, if we get feedback that it's ineffective, we can go back and look at the regulations at a later date, but it should simplify and streamline that for everyone. Sorry, I skipped ahead. Who will make development assessment decisions? So I've already touched on that a little bit, but this diagram just starts to clarify who can make what sort of decisions. So obviously in terms of accepted development, there's no planning consent, so no authority. For deemed to satisfy, it may be an accredited professional, and I'll talk a bit more about that in a moment, or a council assessment manager. For performance assessed, it can be the assessment manager of a council or the assessment panel where there's public notification. And then for restricted development, the State Planning Commission, impact assess the minister. This is a little bit hard to read, but it goes through the levels of accreditation. So this is where it becomes relevant to all the planners in the room who are intending to become accredited. So if you would like to be an assessment manager of a council, you may actually be a private sector person who is engaged by the council. So I've been asked the question, certainly in the regions, if they haven't got an assessment manager within their council, what do they do? One of the options for them is to engage a private sector professional that they are satisfied with, and those persons can act on the council's behalf. And they may choose to appoint somebody that they share among a group of councils and that they jointly fund that person to undertake the work. But the assessment manager is the highest level of accreditation. They have a very important role in supporting the development assessment panel, but they also make decisions in their own right. So therefore, highly accountable, experienced person required to undertake that role. They may delegate within a council. They may choose to delegate certain functions to their staff, and those staff do not necessarily need to become accredited. If the staff are undertaking deemed to satisfy applications, they need to be accredited at that level to undertake those functions. And that is because an assessment manager is not, shouldn't really be delegating those applications. For assessment panels are expected to have a diverse range of skills. So they may not have planning skills, they may have related disciplines, and they will be undertaking code-assessed type assessments where there is public notification required. So we thought that it's important that if there's a public notification and the potential for a public hearing to be held, that there is that chance for that to be undertaken by an assessment panel. And that was pretty consistent feedback that we received throughout the process. For the planning level 3, they can assess deemed to satisfy applications and also those deemed to satisfy applications with minor variations. Which is sort of similar to what we have now for the residential code. For level 4, they can only undertake deemed to satisfy development. So that means that they cannot undertake deemed to satisfy development with variations. So if it varies from the rules, then they can't undertake those. And then for the accredited professional surveyor, they can undertake the planning consent only for land divisions that are deemed to satisfy. Now, at the moment, the code, you might notice, does not have any land division that is deemed to satisfy. We are looking at how we would do that in the regional code where you already have an approved land use, and therefore the land division to create the allotment may be deemed to satisfy. So that's an example of what we might be talking about here, or you might have an example where it might be one allotment into two. But the statement of requirements and the detail needs to still be undertaken by the council, which is the assessment manager. So how do you become an accredited professional? So we've had our website set up now, so you can go into the SA Planning Portal, Accredited Professionals. If you click on there, it asks you to set up a username, and you can do that, and it emails you a username and password. Once you've got that, you can just log into the system, and it allows you to lodge all your information to become an accredited professional online. If you have any problems with that, we have an email address where you can email directly to us, and we can provide you with some support for doing that. If you are creating your account online, there is an evaluation fee that goes with that. So if you're looking for a level 1 accredited professional, it is a fee of $760 for a level 1. In the first instance, you need to have all the skills and qualifications, but you don't need to have undertaken a peer review. A peer review needs to be undertaken, or evaluated peer review, within 2 years of becoming accredited as part of the transitional arrangements. And what that means is that you need to undertake some sort of assessment during that 2-year period to demonstrate your skills and knowledge. You also need to meet your CPD obligations. If you are a member of an equivalent scheme, such as the Planning Institute of Australia, that fee does drop down to $270, so it's reduced. For those who are planning levels 2, 3 and 4, then the fee is $560 and reduced for if you're a peer equivalent. So in terms of the recognised equivalent scheme, very quickly, if you are a recognised Planning Institute of Australia registered planner right now, you can apply for the Accredited Professional Planning Level 1. If you are a PIA full member, you must complete that, and that's assuming you've already done your peer review through the Planning Institute, which you need to have done to achieve that. If you haven't and you're a PIA full member, then you can also register with Level 1, but you've got that transitional period. If you're a PIA full member or a PIA registered planner, you can be an accredited professional planning level 2. And if you're a planning full member, the member must demonstrate the minimum 3 years experience requirement, and then you can be a planning level 3. So you can see where that fits for you at the moment. So if you have that, then you go to PIA, you get your certificate, and you come into us and you lodge your certificate with your other information. So very quickly, on the SA Planning Portal, we are making significant progress on the development assessment processing workflow to start to see how that all starts to hang together. I think it will be an excellent opportunity for anyone who does development assessment in this state. Applications will essentially be lodged online. They will be forwarded out to the relevant authority, and that may include if it's a private sector accredited professional. You are able to then have a log of all the applications that you have in the system and monitor where they are at. It will flag with you timeframes, tell you where you are in the process, and if you are becoming close to overtime, it will let you know. It will also do electronically a lot of the things that we do manually today in terms of distributing out information, and a lot of it will be set up for you through a series of templates that you can then press buttons and things happen. It's quite magic, really. So for those of you who have already got e-planning solutions in your councils, you probably know the magic of this system that can do so much for you and take a lot of the administration out of your tasks. For those that don't, we will be providing significant support in terms of education and training to help you adapt to the new system. But it will certainly make it a lot easier for both applicants and assessing authorities. For those that do lodge on behalf of applicants, you'll also be able to have a login and see where all the applications you have lodged are in the system at any time. So you'll have a list of all your applications, who's assessing them and at what point they are in the system. So I think that's got some significant benefits there. So look, I think a lot of you know that we're rolling out the code in 3 phases, and the electronic version of the code won't be available until phase 2, so that's for the outback areas. We're currently just finished consultation on the that was the regions I meant to say. The outback areas is now planned to be in operation hopefully by July or middle of the year, and that will come in along with the assessment regulations will come in at the same time. So we also have the first version of the workflow available for people to be able to lodge applications for the outback online, but it won't be the full bells and whistles system at that time with full integration. By the regional areas, it'll be a lot more of an integrated electronic system, so we will have a much more sophisticated system for those in regional councils to be able to have applications lodged online, and that will continue to be finessed and improved as we roll it out into the metropolitan area. I won't go through this because I think you know that stuff. But in terms of the submissions that we have received on the Outback Code, we had 57 submissions, 20 from councils, 18 from industries and 9 from government agencies. Most of the feedback we received was that we could do, a lot of it was about finessing wording. So clarity of wording to make the provisions tighter. So that was, we had a lot of suggestions about how we can do that better. So we've been taking a lot of that on board. So for those of you who did do line by line submissions, thank you. We are actually using that information right now. Some of the deemed to satisfy were considered too open-ended, so tightening those up a lot more, and also adding a lot of other additional deemed to satisfy solutions, which we've taken from other jurisdictions. So we did a bit of a search across Australia and looked at what were the best deemed to satisfy types of provisions and how they would apply here, and compared some of that to development plans now. So we could increase some of the provisions around that. The other thing was around definitions. So we're continuing to stage work on definitions. We've got our legal advisors at the moment looking at the wording of those definitions to keep them really tight. It's been quite challenging because there are a lot of terms that we use in development plans that we're all familiar with, and we have to work out the right balance of how many terms we define in the code versus leave up to existing case law that's been in operation for quite a long time. So we're conscious of not being too disruptive and creating a lot of questions, legal questions. So we're trying to find the right balance here between providing more definition but not opening up the door to more debate. So that's been very important. And then there's the basic rationalisation of policy, which we get pretty consistent message. So in terms of, I've gone past this one, did I? So over the coming weeks as well, the State Planning Commission is going to be releasing a suite of position statements. So we have heard from many people that they're not interested in really long documents to provide lots of comments on at this stage, because we are at a point now where we're trying to get the code out for consultation, the regional code. So what the Commission has done is been preparing some really concise policy position statements that help people understand what the code will do. The consultation detail will be in the code itself, but this is to help people understand it before the code itself comes out. So heritage and character is probably the most prominent of those, which will be out very soon, and that's starting to set the scene for what the code will do in terms of character and heritage. So you'll be seeing some more information about that later in the week. So in terms of supporting practitioners, we will have a lot of training on our IT systems prior to go live. We'll have other sessions like this where you can ask lots of questions. We'll have a suite of learning modules that are becoming available from June. We already have the elected members toolkit, so for those in local government, I'm not sure if you're using that, but we'd be really keen to get any feedback on whether you're finding that helpful in talking to your elected members. We'll also we've hired some real strong professionals in engagement to help us to start to frame up a really solid engagement strategy for the next couple of months as we release the regional code as well. And once again, keeping the SA Planning Portal up to date, so please look for that and sign up for the updates. Some quick myths that we've been hearing that I thought I might share with you before we go to the panel. One of the things we're hearing a lot out there, particularly in the community, is that heritage protections will be removed from the system. This is not the case at all. So there was a very strong commitment through the government that local heritage places would be transitioned over from development plans into the Planning and Design Code, and that is still the case. State heritage protections will also be maintained. So what the intention is to get more consistent wording and policy, and that is transparent and clear, so people know what the policies mean for them. The other one is that demolition of local heritage places is non-complying in most development plans. Searching through most development plans, that's actually quite a few. There's only a few development plans where that is actually the case. So there seems to be a myth going around that at the moment it's non-complying, and if it's merit, we would get demolition everywhere. It's clearly not the case at the moment. The other thing is that character policies will be lost in the code. we're very conscious that it's critical for local communities that that doesn't happen, and that where policy has a place and work to do, it will be retained. So we will find a way of making sure that local content that drives local outcomes will be protected, but you will find that there'll be commonalities between different areas in terms of what those characteristics are that you're writing policy to. So character is everywhere, as we know. It's in every area. It's the value that we place on particular attributes that's important. So in that case, we make a value judgment on what character is more important than others, often based on the consultation we undertake with communities. So that's going to be very important for us as we move forward. It is a good time though for council staff to be looking at their development plan and identifying some of those local content that's important. The other one I hear a lot is that councils no longer have a role in planning. The role in assessment has been reduced for councils as in terms of council elected members, but there is still a strong emphasis on community engagement, strategic planning and policy development. And even though the code will have a suite of content, how that's applied will very much be up to local councils to look through and as they undertake code amendments into the future. The other thing is some people even say we don't need many planners anymore. Well, we don't think that that is true. I think there's definitely potential for growth in the private sector in certain areas of planning. Deemed to satisfy applications will be an increased opportunity for private sector to grow and thrive and develop business around that. There is also a strong emphasis in community engagement, and I think planners will become more specialised in those community engagement skills, and the department is really keen with PIA to continue to support development in that space. The other area I think is design, so professionals becoming more aware of design policies and how you use performance-based planning going forward. So there'll be particularly strong areas for planners to build skills and knowledge in, and I know many of you have that already, but it's just continuing to build up that expertise. The other area I think is infrastructure negotiation. I think planners will get much more involved in infrastructure negotiations. I think this is at a state level for high level infrastructure planning. Certainly within our department we're getting much more hands-on with our colleagues about infrastructure, but I think right down to the local level and individual sites, us as planners have great skills to negotiate and bring people together and come up with good schemes for infrastructure. So I'd like to throw that one out to you to get more involved in understanding what the infrastructure schemes could mean for you in the planning profession. Last two, private sector decisions will result in poor decision making. We think that the accreditation scheme is very strong and robust in the way that it's been framed up. There's a very strong code of conduct. There's auditing and compliance. So if you're in the private sector, you do need to be audited every 5 years. That means that your decisions can be audited as well as the process that you've undertaken in conducting yourself. If there are complaints, then the complaints can be acted upon through DIPTI, so we can instigate our own audit if there are complaints. There is a requirement for CPD and to enhance decision making, and we also need to be evaluated to make sure you have the right skills, knowledge and experience to undertake the role. So it's tighter than ever when we talk about private sector decision making. Also with the e-planning solution, all applications being lodged and processed online in one central system means that you can report on statistics around a whole range of things that help us to see how the system is performing. We also have a lot of people that are thinking that automated decisions will be occurring now, like we'll be automating decisions through the current e-planning solution. We're still some way from that. There's a lot of technology that we need to build and develop before we can do any sort of automated machine learning decisions. We also would need to change the legislation because at the moment it still requires a human to be involved. So they're just a few myths or stories that I've been hearing frequently and the team have been hearing that I thought that I would clarify with you.
Okay, so on the panel tonight I have Anita, Alan from TIPTI, obviously, Kate Hart, who's the CEO of Prospect City Council, and also is the PIA Board Director from South Australia. And I've also invited Chris Zafiropoulos from City of Salisbury to give, for both Kate and Chris can give a local government perspective about some of the challenges that they're looking at from implementing the reforms from their perspective. In the audience, Sally Smith was around. just disappeared. And David Williams, the PIA Chief Executive, is also here. He's interested to hear your thoughts on PIA memberships and fees going this way and fees going that way. So he's here to listen and learn as well. Okay, so to start off with, I'll just pose a question, and then I'm not sure whether there were any questions that have come through on the live stream yet and where they're coming from, but anyway, I'll figure that out as we go. So first of all, what I wanted to do, now I've got a technical difficulty with my phone. Sorry. The first question that I wanted to ask Anita and the rest of the panel, how many staff should council have accredited with accreditation, particularly assessment managers, given leave or even resignations and those types of things? And then I just want to pose that question to Chris and Kate about what their thoughts are or what their council are dealing with regards to that question.
That's a hard question to answer. It probably does depend on the size of your council and the number of volume of applications that you do with each year. But I would have thought it'd be useful to have 2 people accredited, or to have a backup plan. So you may well have like I was talking about earlier, you may have a private sector person that you feel comfortable with appointing as an accredited professional assessment manager as a backup person, and then have a person that's your one full-time person. Or alternatively, you may like to accredit 2 people and have them both, when one's going on leave, the other one can act in that capacity. But I would have thought you will need at least one backup plan for that.
Thanks, Anita. I tend to agree with that. I think certainly from a smaller council perspective, I think local government will need to have at least one assessment manager, but I'm very keen on looking at an opportunity around shared services. So whether it's set up in a regional model or whether you have a relationship with an adjoining council that you can call on the adjoining council to assist. And that does very much rely on a partnered approach at the CEO level as well as at the director level. So we'll certainly be looking at the size of councils and suggesting that a smaller council definitely needs to have at least one. I don't think it's appropriate not to have any, so we'd certainly be looking at supporting that, but a larger council may have the capacity to have 2 or 3, subject to the volume of applications coming through. And if you can't get that, then building a partnership with an adjoining council or on a regional basis.
That's okay. Yeah, I shared a view, and I should probably qualify, I don't speak behalf of the City of Salisbury, so our CEO will need to sign off on this, but I think there are 2 parts to this. I think you need to have at least a couple of assessment managers within council, because there may be conflict, maybe someone may leave, so you need to better sort of, I guess, respond and do matters fairly quickly in that circumstance. I think also when you look through the different levels of accreditation, I think just for the ability for people to, I guess, grow and develop careers, I think for a larger council, for us, we need to look at sort of, I guess, how we sort of have people in our team at different levels of accreditation, so there's career progression, and I think there's probably the 2 driving forces. We'll know more as the code gets rolled out and we see some of the detail. I guess we'll have a clearer picture, but I think certainly at this stage I think you need to look fairly broadly.
The one thing I would say is you can only have one assessment manager for each assessment panel operating at each time. So it's only really to backfill when that person is unavailable.
I'm just going to pose one more question as well. So as a private certifier, what are my responsibilities in deciding to take on a job during the assessment and then also post-assessment? Am I responsible for compliance?
So compliance is still a function of the local authority in terms of the application. The accredited professional is only responsible for that assessment function.
And then I suppose the question for Chris and Kate, are there concerns with that with local government in terms of complying or following up compliance on something that's been through a private certifier? And if so, how are you looking at dealing with that?
I think there is a significant concern on that issue. We already have some private certification happening through the Res Code, and we can have differences of opinion as to whether the private certifier has actually operated appropriately or has issued a consent that we would agree with, and that then results in us actually having to engage in a discourse with the applicant and the private certifier and potentially the court. So I think it is a point of conflict. I don't know how we will continue to manage that at this point in time. We'll really be subject to how the private certification is adopted by the general community. Do they see it as a easier way of getting a planning approval? Then I think we will certainly be having to increase resources to manage any issues where we've got a different view and or a consent submission or we don't support it. And there's a lot of politics that sit behind that, and I am concerned that from a political perspective, councillors will want to get involved in the debate and then we'll be managing that side as well.
Yeah, it's a current tension, so I think we have that now, and I think it plays out differently in different councils. I guess what my thoughts are on this is that maybe that's where the practice directions or guidelines, I'm not sure the right one is, but I think the system benefits some guidance around that in terms of the role of compliance. Obviously, a certifier can't be authorised, they can't access land, so they can't go onto land. It's the role of council. But I think when there is that differing opinion, I think it'd be good some clarity of, I guess, the role we play in that and how we resolve that conflict.
I mean, certainly when we start to look at the fees and charges schedule for how you set up fees and charges for applications, it's important to understand the whole of the system. So what are all the different components of an application, which include audit functions, compliance functions. So we're certainly looking at that in the long term as we start to establish fees. As part of the first fees that we're having to deliver for July, we're keeping the fees largely what they are now because we're largely introducing that for the outback areas. But we will be undertaking a more thorough review and investigation into fees and how they can be set to make sure we appropriately cover the types of activities that come with assessment.
Yeah, I mean, I think it is challenging. We see it through the building code where we get private certification of buildings and local government doesn't receive any of that fee, and then having to actually ensure compliance in terms of issuing either the development consent and or doing the compliance to make sure that building has been constructed in accordance with the approval. And local government, I think, is disadvantaged significantly by the private certification and that fee, not actually having a fee allocated for compliance.
Yeah. And certainly in relation to inspection fees and private certification of building rules, we are looking at that.
Yeah.
Yeah, there's a question at the back there. You'll just need to speak into the roving mic so that those that are on the live stream can hear your question as well.
Yeah, thanks. My question's probably a little bit eclectic in that it's something that's come to mind during the discussion. May not be specifically relevant to the topic currently being discussed about fees. What the question is I'm assuming that the private sector consultants will be able to run their own advertising public notification processes. Is that correct?
I will have to check that. I believe that they can, but yep. I don't see any reason why you would, because a private sector accredited professional can only do deemed to satisfy applications which aren't notified. So thinking about that, that wouldn't be the case. That would always be the...
Yep. Yeah. I was just thinking that the issue of where there are differences of opinion between the council and the consultants, how that might play itself out. Could you comment on that?
Well, at the end of the day, the relevant authority is the relevant authority. So if the relevant authority is an accredited professional, their decision stands. They're the decision maker. So it is up to the courts really to intervene if there's a challenge against whether that accredited professional should have made that decision. Is really a legal question. It's not really the council's question to come in and intervene in an application that has been assessed by a different authority. So I think where it becomes challenging is where council's required to issue development approval, and that's where they pick up whether they do or don't agree with it. But at the end of the day, they just need to check, it's just a consistency check to make sure all the plans are recorded and there is a method of making sure that they can be retrieved. So it's not necessarily for them to reevaluate the assessment. although we understand, Kate's point about the politics around that.
We have to give up our babies.
Yeah.
Yes, another question?
Yeah, thank you. Michael Hihimanis, consultant planner. Can a decision determined by an assessment manager from the private sector be challenged by the relevant authority?
They've actually been appointed by the relevant authority, so no, I don't think so, but that might be something we'd... Sorry?
I think that's why I asked whether the private sector can advertise an application.
Well, I shouldn't say private. I guess I'm using the term private sector loosely, as in they might operate a business, but they are working as a council staff member if you appoint them. So they operate under all the same ICAC requirements, every other requirement that you have as a local government, sort of making an accredited professional making that decision. So
The reason I've actually asked that question is based upon my experience in working in local government many years ago now, and still providing advice to local government authorities, that even within the planning development team of a council, a planner may make an assessment that may not be accepted by a more senior person in that organisation. And that's the reason I'm wondering if somebody externally who is appointed to make or determine an application, it can be vetoed, if you like, by the actual relevant authority.
no. So the reason that happens within a council, and Chris, and Kate, you might want to comment on this, is that it works through delegation. So if the council assessment panel may delegate to their senior staff, and then the senior staff might sub-delegate down to the junior staff, and so each of those people are accountable for the decisions that get made below them still. So it's not like they can say, no, actually I don't want you to make that delegated decision, I'm going to call that one in and do it myself. They can do that. This is different in that you actually are the relevant authority. So the assessment manager is the relevant authority.
Right, okay. Thank you.
Is it?
Maybe, I think my sense where this has been an issue is it's not so much the relevant authority, but where we deal with minor variation, and where the issue's been is a certifier may interpret a minor variation differently to say what a council may do. Now, I guess in the new system is if you work with absolutes and there are numbers, there's less room for discretion, so therefore you may remove that. And it's not, I guess, in my experience as a council, we can't necessarily overturn a decision, but you'd apply to the court. And that's, I guess you want to avoid that. That's kind of giving the practice, and it's played out differently at different times. I guess the benefit of a new system, and we're seeing the code that will come, is I think to sort of get some better definition around that. So I guess we agree broadly as a profession where that minor variation is allowed and to what extent that might be acceptable, as opposed to, no, it sort of kicks it into another assessment pathway.
And they are the types of matters that you can issue practice directions around, which is to provide greater clarity of what a minor variation might be as well.
Darren had a question first.
Thanks, guys. This one's probably for Anita. It's just about paper submissions and versus electronic submissions. So my understanding is we're still going to have to, as a council authority, take paper applications for a period of time, scan them in, and that's what makes it electronic. Is there actually a plan to actually phase that out over time, or is that something that we're going to live with forever? Because obviously that has some resource implications. I think I'm seeing some nodding. I think most councils would prefer it to just go electronic, but understanding the customer service aspect of it. But are we looking at it as a 2-year, a 5-year, or is it something that might go forever?
Look, I don't have the precise answer for you yet, but I do agree. If it wasn't that we had so many people who still are not electronic, we would do that. And my electronic team, the guys in the team every day want me to do that. Love to. I do think we have to phase it in. So what we have agreed within the team is to start looking at, do you charge a slightly higher fee for somebody who lodges in paper, because that's an administrative burden for the council to then scan it in. into the system, and there's a task that they would need to do there. So that is something that we're looking at as a disincentive. The other thing is that I think we will like to phase that out over time, but what the time frame is, I think it's about monitoring how many we're receiving on paper, and with the electronic system we'll be able to do that. So we'll be able to say what percentage are on paper and then start to look at who are lodging those. I think as we move to private sector practitioners will be lodging more and more online. That's just the way the world is going. It's more the smaller scale people that need to adapt to the change, and that might take them a few years.
I think it is going to be an issue, a service issue, and there's no doubt that I know my team and other councils are concerned about the resource it's going to take to deliver that service, and without a requirement to do it electronically, it's almost going to be impossible to phase it out. You know, we'll still have staff, and I've got a dedicated information management officer doing planning work scanning, and I'd love not to do that. So it's going to be a challenge, I think, to move it all electronically, but I think we should be pushing the point and saying that's what you do. If you're going to charge a higher fee, I don't know how you then determine what an appropriate fee is that would go back to the council to cover the cost of that resource. Because the point is just charging a higher fee as a disincentive. The local government would want to actually get the compensation back in order to be able to support the service.
Yeah, and the intention would be that if we recovered that fee, it would be go back to the authority who did the scanning work. Yeah. Yeah.
Thank you. Does this work? Can you? Brian Hayes, a barrister. Can I go back to the private certification, because I think that's become very important in recent times, particularly with the building, under the building provisions. And as I understand it, the assessment officer or the assessment professional will be part of the council team, and the council is the relevant authority, so that's not a problem there. But with the private certifier, he will not be the relevant authority. The council will be the relevant authority. That's very similar to what we have at the moment with the building provisions. And we have, as Kate has pointed out, this dilemma between, you know, the private certifier saying that it comprises, in this case, the deemed approval. Yes, it complies. The council has to do something when it gets the application to deal with finally, which includes looking at that assessment and agreeing with it, or has no role to play in saying whether it complies or not. The reason I ask this is because very recently I spoke at the Building Surveyors Conference, and I nearly gave them all a heart attack when I mentioned, I did a proposal there where I mentioned that under the Development Act, there's not only civil liability, there's criminal liability, i.e. criminal negligence. So if a wall falls down and kills a worker, that certifier may well be guilty of criminal negligence if he has been, if it can be proved to be the case. Now, is it still what is proposed to be the council having to make an assessment about the certifier? Has he, or should the council be second guessing that? Or has someone got the ultimate responsibility, the certifier or the council, as to whether this is deemed approved? And you say then it's a matter of law. Well, when it goes up to the court and the court says, no, it's not deemed approval because he's made a mistake or he's been negligent, does the council have a role in that? I mean, have you looked at that aspect in terms of the legislation?
I'm trying to follow that logic, but I mean, at the end of the day, whoever is the authority makes the decision. The council at the end does issue development approval, but that's the assessment of the building rules has still been undertaken. Assessed it to be appropriate against the building rules. So the council's roles are not then to go and reassess the building rules and see if it meets the building rules. They have to accept the private certification that says it does. The same goes for the planning consent. If the two consents look totally inconsistent with each other, I mean, that's when you question whether you issue development approval because the consents aren't consistent. If they are consistent with each other, then the council must issue development approval. And
It's
so
the
the
same as it
liability
is at
sits,
the moment.
yeah, the liability sits with the person that makes the decision.
Okay, thanks.
I've got a question either for David or Kim, actually. I'm just wondering whether PIA has done a bit of any homework yet about looking at in terms of its registered planners or members, in terms of as we move into the new accredited scheme, how many people can actually translate over, and in a sense, are we ready for it? Because I know we've got a lot of registered planners out, or a number, but not all of them are in local government or doing sort of DA work. So, it could give us some false confidence that we've got these people, but whether they're in fact ready to do the work. So I didn't know whether PIA's actually looked at its membership and sort of put any thinking into that at this stage.
I'll look at David because he's done all the negotiations.
Thanks, Stephen. Yes, we have looked at it, and the secret sauce here is the transition period. So a full member can apply and become a level 1 professional, and then has 2 years to complete, if you're a PIA member, your registered planner. So you've got that window, and we have the ability with our assessment team for that to scale up. So we're ready to scale, and we can do that in terms of the number of assessors we have on the team, but also the number of marking windows. So we can scale both ways, and we're ready to respond if needed. We think we're talking in terms of probably somewhere around 80 to 100 assessments over the next 2 years, and that's quite doable for us.
So, and just to be clear about the timeframes, is that only those that are operating in the outback will be required to be operating in the regions, and that includes assessment panels or their assessment managers will be around November. So I think we're looking at a date of about the 1st of November. Don't quote me on it, but for the metropolitan area it will be July. So for building certifiers, they can get, there's transitional arrangements for them, for those who are transitioning from the Development Act, so they can operate across all of them. But so you just have to consider where you're operating and whether you need to be, what the timing of when you need to be accredited.
Hi, my question is for you, Anita. There have been a few questions with the exception probably of the last one, which do revolve around private certification, and it is a big live issue. I think my friend Brian and I are on the coalface of a lot of the real disaster stories when it comes to litigation involving certified decisions. And Anita, before you mentioned the new accreditation scheme and how that is envisaged to be, I guess, the linchpin to raising standards and ensuring that there are less disputes around these decisions. My question is, has DIPT looked at resourcing for enforcement of the accreditation scheme and the associated regulations, and are there any plans to increase resourcing, or otherwise how is DIPT going to deal with complaints that come in under the scheme?
Yes. So the short answer to that is yes. So when in introducing the scheme, we looked at the number of appeals, because we also have the potential for appeals to SACAT. So if you are refused accreditation, you do have a right of appeal to SACAT. So we've looked at the resourcing for SACAT and for DIPT in dealing with compliance and auditing functions. And that's, so there's the standard, the 5-yearly audit is actually funded by the accredited professionals, so they'll have to undertake their own audit. And that's if they're in the private sector. So we did give dispensation to local government employees because there are already audit programs within local government, and we'll continue to work with the LGA on how they're run. But there are the random audits that we can undertake, and obviously be more complaints driven. So we have looked at the resourcing within DIPT to support that function.
My question, because I've been hearing that the volume coming to CAPS may be an issue, and that it's proposed that may be resolved through delegation back to the assessment manager. On what basis do you envisage that those decisions occurring? Because I thought the whole point was to have consistency across the system. So how do you envisage CAP panels making decisions about delegation into the future?
So there's two parts to that. One is that the council assessment panel will always be able to delegate down, and we are working with the LGA on coming up with a standard suite of delegations that councils could adopt. Now, of course, it will be up to the council assessment panel to fully adopt those delegations, but we will have a starting point for them, which will move towards as much consistency as possible. On the other side of it, what we heard from people that they wanted less going to council assessment panels, so we are investigating how we could reduce that and put more to the assessment manager. So there's the two ways of looking at that.
Hi, I had a two-part question. The first is in relation to accreditation for planning staff at councils. I had anticipated that a lot of councils would allow their assessment managers to delegate to staff, and things would essentially operate in much the same way that they would now, that if a staff has delegation then they sign it off and that's fine. You mentioned earlier that you didn't anticipate that assessment managers would likely delegate DTS development, deemed to satisfied development, if the staff were capable of being accredited at that level. But in my mind, that would mean that that decision is issued by, say, Emily Crook as an accredited professional, not Emily Crook as a delegate of the assessment manager of NPSP. And then if someone wanted to appeal that, procedurally or otherwise, then the appeal would be in my name rather than the council or the assessment manager it would be. And that could get quite messy. So I anticipate that most councils would have their assessment managers delegate all decisions regardless of whether or not it's performance assessed or DTS. And I suppose I was interested in everyone's opinions on that. The second part was with respect to the building officers. That obviously, the draft regulations says that councils must take the advice of an accredited person when they're issuing building consent. So it's a bit different to delegation. Do you anticipate that an accredited building professional is reviewing every application, in which case I think most councils will get all of their building officers accredited? I'm interested in people's opinions on that too.
To be honest, I'm not sure about that second one. I might have to look at it. But yeah, I guess I was just looking back at the assessment manager question. They are actually the authority for deemed to satisfy development, which means it's quite fine for them to delegate it down. So sorry about that. I was a bit unclear before in reading it. So yeah, that can happen. That's no problem if that was the way the councils choose. Alternatively, a council could choose to set up a small accredited professionals group within the council who dealt with deemed to satisfy, and they just ran a service essentially. They did that. So there's lots of different ways that a council may wish to organise itself to deal with it. I'm not sure that whether it would or wouldn't. It's probably something that you'd have to check with through the LGA, through the mutual liability scheme. There's a question for you, Stephen. Just to cover what Stephen has said for those on the live stream, this is a matter I think that would need to be looked at in more detail. So we could perhaps go back and address that question.
Yep. It's another question, but different, about the accreditation scheme. Sorry, over here. Nita? Yep. Hi. Question about the future of the scheme and extending it to policy, the policy function. Obviously, the focus on assessment now, but I'm just wondering in terms of the plan to extend the scheme to policy.
Yes. So we did look at that quite carefully because we did receive a lot of commentary around that during the discussion paper when it was out for public consultation. The advice that we received was that the accreditation scheme is only set up for assessment under the Act, so we weren't able to do that. However, we can certainly say through regulation the types of experience that people need to provide advice on policy, and that's something I think we can continue to look at into the future, but we haven't proposed anything at this stage.
I'd probably suggest to you that certainly I think from a local government perspective there'd be a hesitancy for a council to delegate policy establishment, so without them signing off on it. So you could actually have a situation of having a accredited planner doing the policy work, but then the local government would actually be on behalf of local government, not an accredited planner doing policy work, which would then be approved under some form of delegation, some form of accreditation. There's just local government just won't actually let go of that, and I don't think they should.
And I think we're talking a little bit about what we've got as a Section 101 requirement at the moment, which some of you might be aware of needing. But I agree with Kate that at the end of the day, there's lots of different opportunities for review when it comes to rezonings in particular. So you've got the State Planning Commission providing advice, you've got the Minister and the Council all reviewing rezonings.
Yeah, I'd certainly...
I think interstate, I could be corrected, but I think some major developments interstate, they'd actually do a rezoning as part of the development application. We don't actually see that happening here, and local government would be hesitant to see that provision come into the state.
Yeah, I'd certainly agree that the function would be different if you looked at it in a policy sense. Certainly don't agree you'd delegate the whole decision to an accredited professional. I agree with you there in terms of, like, I guess it's questions around the role, to grow in the role of the policy role within that aspect of the system.
I've got a question. Sorry if I've got myself a bit confused here, but when we appointed our assessment manager, the advice from DIPTI at the time was that we had to appoint it to a person and not a position, which we've done. And I know that we should probably have the backup at a level 1. So just the logistics of that, does that mean we're going to have to change, like go through the CEO every time our assessment manager goes on leave or is sick or whatever?
Yes, so I mean it's not unusual for delegations to be prepared and somebody, not within DIPTI, we do it all the time, Sally goes and there's her delegations are essentially signed over to me as a formal acting role. So that's not an unusual situation for that to happen. So yeah, it's pretty much what happens now.
I'd support that approach. I think it might be more challenging in a smaller council, but if you have your delegation set up appropriately, then if the assessment manager is on leave, that council would need to appoint an acting assessment manager, and then the delegation could be transferred through the application of that rather than trying to get somebody else in.
I think the question though was that because the accreditation lies with the person, not the delegation or the position, how would that work?
So people can be accredited at level 1, so as an assessment manager level. So this is why we took the term assessment manager out of the reg, so now it just calls it level 1. So you can be accredited at a level 1 and a level 2 and a level 3 if you want to. And if you were a private consultant, you might well choose to do that so that you could be appointed at any time to act in any of those roles. So you might say you would have 2 people accredited as level 1s. One of them is the assessment manager. When that person goes on leave, you sign off, the CEO signs a piece of paper that says this person for this period of time is the assessment manager.
So just because you're accredited as an assessment manager doesn't make you an assessment manager. Correct. You have to be in that position, appointed to that position as a consultant or as a employee of the relevant authority.
Absolutely.
So if you used a consultant company, you'd have to get the name of the person and make sure, so you couldn't say use blah 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 company.
No.
You've got to find out. Yeah, individual.
Which happens across a number of different disciplines already.
Yeah.
No, but smaller councils, it's very difficult.
The person is making important decisions and providing the council with important advice. So you want to make sure that the person that's doing that has the right qualifications and experience. to do so and is accredited at the right level. So it is important that the accreditation sits with the person, the appointment sits with the person.
Okay, we've just got one from the live feed that I'll just read out. I think it's on a very similar topic that's come in from Wattle Range Council. Accreditation in regional areas is an issue. How will DIPTI look at a regional council which has a manager or director who are not planners but say building certifier or planning officer who undertakes most or all of the assessment? Will this make them level 1 assessment manager given they have qualifications?
So, I mean, if the person is qualified as a planner and they have the right skills and experience, then they can be accredited at a level 1. If they can, there is opportunities to do conditional accreditation. So if the person is largely working in a council where 99% of what they do is sheds or large just outbuildings, that'd be a different story than if they were in the metropolitan area where they're dealing with a really diverse range of applications every day. So out in the regions, it may be appropriate to issue conditional accreditation, and there may need to be a commitment to upskilling knowledge and expertise over a period of time to be able to remove those conditions. I don't know if that helps answer that question. The other option, of course, is to work regionally, like Kate's suggesting, and groups of CEOs get together. We've got a number of councils who are working to set up joint planning boards. That's an excellent opportunity to have the conversation about how you could work together on setting up a joint assessment panel, and how that joint assessment panel could then be supported by one assessment manager. To be honest, the system is going towards regionalisation and supporting regional assessment where it's efficient and effective to do so, and the opportunity is there to take those efficiency gains that you can get out of those approaches. So the important thing here is that we're trying to improve decision making in both the city context but also out in the regions. The regions do deal with from time to time some pretty complex stuff that has huge social and economic impacts for their community. So making sure you're getting the right advice is still very important.
I think it is actually going to be quite challenging in the regions, and having worked in the regions and know a lot of CEOs in the regions, they'll have a planner who will actually do the assessment, but their panel would have actually delegated their CEO the authority to sign off on the consent, and that's not going to happen anymore. And so I think we actually need to work very closely with CEOs in regions and in local government to provide as much support as possible, because the signing off on a hay shed, which might have been quite straightforward before, under delegation from the panel, is not going to be able to occur anymore, because it'll have to go through the assessment manager.
Yeah.
Oh, thanks, Kim.
Hopefully it's deemed to satisfy.
Yes.
This question, Phil Brunning, consultant planner. This question maybe for Anita. Has any work been done with the insurance industry in terms of the risks that a consultant planner will take on as a planning level 1 accreditation? In other words, what's the rub in terms of public liability insurance?
You will need it, but
stacks of it, I think.
You will need insurance. Look, to be honest with you, Phil, we haven't done a lot of work with the insurance.
How about PIA?
At the moment?
Protecting members' interests?
No, but it's our next task is in fact to work with Planned Cover, who is a firm that many of the consulting planners deal with, and explain to them A, the scheme, and B, what a registered planner is and the competency set, etc. So those discussions have commenced. We just don't have the outcome yet to advise.
Good.
Good evening, Michael Davis. I just wanted to ask a question, I suppose, for Anita. Very limited range of things currently would fall within the deemed to satisfy. And obviously a lot of the questions and the comments have come around the kind of private certification process. Just your thoughts on how much deemed to satisfy would actually be in phases 2 and 3 of the code upcoming? Just sort of maybe a bit of a segue towards the code. And
yeah, it's a good question. So I think where we were tentative in going out with the Outback Code, and in fact it's actually harder to write deemed to satisfy, you wouldn't believe it, for the Outback than other areas, because you're not sure what's coming and it's quite random, so it's less predictable in some respects, and the zoning that you provide is quite flexible, so you allow for quite a diverse range of uses in the Outback. As you move into zones that are more around existing neighbourhoods that are already being developed, the types of development that get there is much more predictable, and in fact much easier therefore to write deemed to satisfy provisions around. I think in our residential areas, and let's put character and heritage areas to one side for the moment, but you really should be getting, I hate to throw figures out there, but my ambition would be that we get 80% of our dwellings to be deemed to satisfy, and having the provisions good enough and robust enough for local areas to be able to achieve that outcome. So that is ambitious, but really the place we don't want to spend too much time is the everyday sheds, carports, verandas and dwellings. And even if you took most of those off the books, that's 80% of the applications that we get within Greater Adelaide at the moment. So the remainder where we talk about deemed to satisfy for commercial, mixed use stuff, retail, you'll be able to get some deemed to satisfy there, particularly around change of use applications. But it is harder to predict the exact nature and form of those more complex forms of development. Some industrial land uses are quite easy to predict, and you can put deemed to satisfy provisions, particularly around light industry. But I would think that the residential space is still the easiest space to get wins on the board, and then you'll be starting to look at other components. That doesn't mean there won't be numerical standards in the code relating to those others.
I'd like to make a comment about professional indemnity insurance and then ask a question. I had a meeting last week with Plan Cover. I introduced the idea of the new planning system and how and asked questions about how that might impact me. My sense is that we need PIA needs some good legal advice to support a Plan Cover's understanding of the planning system generally, and that might go for the building sector as well, I think, building surveyors. My question is about competition in a sense, because I'd like to know about fees in the new system. I work as I'm a private certifier. I haven't done much private certification because I'm terrified of my professional indemnity insurance, the implications of liability. But I would like to know, I would like to start planning for the new planning system in terms of commercially. I'd like to know how you're striking fees that might be balanced in terms of private sector involvement in the planning system.
So my understanding of the fees, how they work, is the fee will be set, but if a private certifier wants to do it at a lesser cost, or more, I understand that you could do that, but I'm not sure, actually not sure about the more. I'll have to, can I take that one on notice around whether you can charge more? I think you would be able to, because if you're providing a more, if you could make a case that you're doing a more efficient service, but I haven't actually looked at that legally to see if that's 100% correct. Well,
but
I believe that would continue.
Is a great unknown to me, and I don't understand. I mean, hats off to certifiers who can do it less, but I just don't understand how they're doing that. Really.
Yeah, I think it's a good question, and I guess my sense is that the fees are, I guess, dependent on the service. So I'm aware that some certifiers currently will charge more than the minimum prescribed fee, but the client gets a service which they're happy with, and they'll pay for that because it's a consistency across, I guess, all the applications across the state. But in some, I guess, application types, it's very competitive, and I guess there's been an increase in some certifiers, and they're prepared to sort of put their prices at a point to, I guess, attract work, is a better word. So I think it's quite uneven in terms of how it plays out, and it depends on the nature of the work the clients are out there. And yeah, I'm not sure who's going to take the planning space. What my concern would be is if people bid for work, and that's where the aspect of it, and I think it's really important in terms of the the credibility is there's got to be a consistency. It shouldn't matter who you go to. You should be the same decision that should come through the process. So just ensuring that whatever scheme we have and how that works is there is some consistency regardless of who you go to.
We bid for work most of the time. We bid for work every day. But when it comes to bidding against local government planners, it's another matter because there's obviously corporation support behind the council.
Yeah, I guess I use bid in terms of not so much the process but the outcome. I guess so. Yeah.
So, like I said, the first set of fees will come out in July for the Outback, which is largely transitioning over existing fee structures. We are looking at analysing the task of undertaking an assessment under the new scheme. There will be a need to keep monitoring that though, because we can only predict at the moment what it will be in terms of workload and effort for each individual application, and we'll continue to monitor that over time to see to evaluate the fees and whether they're efficient or sufficient.
I think one of the issues in terms of the state setting a fee is then having the state review the fee at an appropriate time to increase it in accordance with increased costs. And we saw the state government quite a few years ago not keeping pace with the cost of doing business and the fees across a wide sector that are established by state government having to be increased over a number of years because they hadn't kept pace with it. So it is a concern if we can't keep pace with the fee, because politically no state government really wants to increase a whole bunch of fees because it can impact on them politically. So I think the system of establishing the range of fees that are going to be applied underneath the Act, and then a review process to ensure they keep pace with cost of doing business, which may be different to CPI, is going to be really important.
Yep, I agree.
One of my questions is, we've talked about it before, and Anita, you've basically explained it pretty well, that the private certifier is the planning authority. This is the application, and the building certifier is the planning authority. But the biggest concern we've got right now, as a private certifier, we've got some councils out there 6 months down the track coming back and saying, sorry, we're not going to approve this application, and the client's gone and gotten all the engineering details done, the whole lot. Under the legislation currently, they haven't got the authority to do that. They've got to grant the development approval, and then they've got to take it to court. They're going vice versa. I think if this is going to work, if an applicant goes to a private certifier for planning and building, then it's going to be lodged electronically on the system. I believe that DEPTI or SCAP should be issuing the DNF and shouldn't be going back to council. The only thing go back to council is the plans and that. Because I've got clients now, 25 clients, we're looking probably will take councils to court because they're fed up because of minor issues that they think that my decisions aren't correct, where I've had the same applications previously been approved by that council, and now they've decided to make a stand on it under the civil matter. Now, I find that as a disgrace from local governments to do that to private certifiers. If they want to go through the right channels, they should take it to court. There has been a court case. It's been issued out and stipulated. And if they've got a complaint, they should issue that complaint to the minister, not take it on board and then hold up and waste taxpayers' money or the residents' money issuing engineering, building and all that, and it comes 6 months down the track. They should issue it as soon as, because we send it off to council straight away. As soon as we issue the DNF, we've got 10 days to issue it back to council, and that's what we do. They should come back with us in 10 days, but they don't. And that's where the biggest dilemma is going to happen with this planning reform, if that's not addressed right now.
So I take your point on board. I think that's a legislative change that you're talking about, which is more in the Act, how it's set in the Act. You can do so much through regulation, but are very difficult to change through the regs.
But like you said before, that council's not the authority.
They're not.
The planning officer is the private certifier and the building certifier, but planning is acting as they're the authority to issue the DNF. And then we're not going to issue the DNF because we're the authority.
Well, the actual DNF should be automatically... so when you approve something, you're talking about the development approval at the end?
Correct.
Yeah. So the development approval is still by the council and that's specified in the Act. So it's not something that we can change at this point in time. It requires legislative reform.
But it doesn't require assessment of the planning decision or the building decision.
It's just got to make sure that it's automatically been granted.
I would assume that if it's not done in the time period, that it's a deemed approval under the new system.
As an example, a private certifier, planning private certifier, has got 10 days to issue planning consent. Okay, I issue planning consent, I give it to the building certifier, he issues building consent, puts his conditions on there. I've got no conditions, okay? He sends off the conditions to council. I've already set council a set of plans with my conditions. Council gets the building certifier and then turns around and says, there's no formality. The only thing they have to do is just issue the DNF. They turn around and say, no, we're not happy with it. So why are they assessing my decision? Where you're saying before that we'll be audited every 5 years over our decision making. It does double handling.
Yeah, I understand the point that you're making. I'll see if there's anything else I can find out for you, but I don't think there's much. Apart from the fact that they have timeframes, they shouldn't be doing that.
Well,
I'm presuming the e-planning system will kind of not enable council to open up a decision again.
It's already made, yeah.
Yeah.
Well, what council's saying to us...
I understand that, but that's the current system. We're now looking forward to the future and how we can resolve that.
Council's thinking they're still going to be issuing the DNF in the future as well.
Yeah, they will be, but they will be doing it within a system that's going to limit them how much they can open it up.
Okay.
So we'll have to be able to look at the planning and the building plans to do a consistency check.
Yeah.
So we'll be looking at them.
Yeah.
Any culture change in local government?
I think just on that point, I guess from my perspective, I think that's where the issue of minor variation comes into it, and that's where a lot of debate occurs. And I think there's certainly a strong need for more clarity on that, because that's where there is a difference of opinion. And council, current new system, will issue the approval. So if the council takes the view that it's been taken to court and it's been proven both ways, wasn't quite right, then they'll sort of take that. So I think there's a need for clarity, because I think not for you, the client or the community, that we should spend time debating these things. And I think right now there's perhaps too much discretion in there, too much interpretation. I think perhaps part of the reform needs some clarity around that. And obviously, in the absolute sense, if it was just numbers, that'd be much simpler. I think it's
at the end of the day, though, the authority is the authority. They make the decision. Council's only role is to check that both plans have been lodged and that a development approval can be issued. It's not to question if they're not happy with it, then they need to put in a complaint against the certifier, and that's when it might trigger an audit. That would be the process. It shouldn't be that poor homeowner who's trying to get their house built and thinks they've got approval, and then you stymie them at the end for 6 months. That's not okay. And I agree that's a cultural question about why would we be doing that to that poor person that's trying to get their house built. At the end of the day, what they should be doing is going back to the system, questioning whether that certifier is doing their job appropriately, triggering an audit, and then that person is looked at to see if they are actually doing the right thing. Take your point, it'd be great to be really clear about what a minor variation is. I've got to tell you that's damn near impossible, but you can try really hard to make that clearer. Looking at you, we know that's almost impossible, but we can certainly tighten it up as much as we can.
I think I have to defend local government here in terms of the role that local government plays around ensuring development is appropriate in a particular locality. And it's all very well for private certifiers to come in and say, I'll accept that variation. But at the end of the day, the local government planners or the local government authority has a role to play in terms of responding then to issues that arise around that development. And that might be a particular scenario you've got, Michael, but at the end of the day, most councils don't have that situation. And you might have a number of clients. Maybe you need to have a look at what the variations are and go and talk to the councils and say, I'm the private certifier, I'm prepared with these variations, why aren't you? And open up a dialogue with them as to why they're trying to come along and say we don't support what you're doing, because clearly you need to build a relationship with the council and say, this is from my planning assessment process, this is minor. And they might say, no, it's not, and you need to work through that. Don't just blame the council on it.
I've worked through council, and basically the one decision is that they say to you, yeah, we agree with you, and I've got one now with one of the councils that face-to-face agreed with me with the decision, the bulk and scale of the building at the front, where the Breach Code doesn't talk about the bulk and scale of the building at the front. And he agreed with me, fine, 2 weeks later he writes to the applicant asking him to change the plans.
Can we put that to the side, because we're here to talk about the new system, not what's happened currently, and there's still a couple of people that want to ask questions and are mindful of time, so we can take that discussion offline. So, sorry, well, I need the microphone to be down there.
I really think that there needs to be some attention paid to transitioning the new system into local government from a cultural perspective, and I wonder whether Kate is thinking about any sort of change program.
There's no doubt that I think sessions like this, all of the sessions that DIPT put on, the way that PIA is working is all about actually working with the new code, and I think there will be a need to review how the planning departments are working, and we can support them on that. But not all councils need a culture change, because they're right at the forefront going, we're supporting this. So there might be a few planners there, but it's not representative of all of local government.
I think the thing that we need to bear in mind as a planning profession is that we are still assessing development application, we're still preparing zoning policy, we're still doing all the things that we're doing. The changes are a change of regulation of process. Processes change all the time in a variety of different ways. You look at where we were 10 years ago with, I don't know, banking online or a whole range of different things. This is just the same. We are here to facilitate you with that change as with DIPT and the rest of the planning community. But it is just a change, and we will get there. We will move across, and we will do it together as a profession.
Yeah. I've established today, I think, that firstly DNFs are still to be produced by local government authorities as opposed to an assessment manager that's external. I've also established today, I've noted from Anita, that an external assessment manager is the relevant authority. So my question is, if an external assessment manager has determined an application and has listed at least one condition, and a more performance assessment may require specified conditions which are specifically based on the actual application. And if indeed an assessment manager, external, can determine applications that have appeal rights, and there is an appeal by either the proponent, the developer generally, or the person that's against the application, if we have those sorts of applications that an assessment manager can determine, which party, the assessment manager or the local government authority, accepts the appeal and is responsible for carrying out the appeal process. And if it's indeed the local government authority, at least at first instance, are they obliged to, or under the system, will automatically bring in the assessment manager to stand by their decision?
So the short answer to that is there are no third-party appeals for code assess development. So that's
I can't see that from the summary of your assessment planning level 1.
No, well that's in the regulation. Well, yeah,
Well, that's
so
right.
I was going to say the second part is judicial review. So under so if it's a third-party appeal, there is none until you get to restricted development, and that is the State Planning Commission is the authority for restricted development. so you're only talking about judicial review. Now, if it...
Also the proponents that may be against conditions.
Challenge the decision.
Yeah.
So if there, I think we're getting a bit caught up on the fact that in a rare case it might be a private sector assessment manager. I don't think that's not the rule. The rule is in 90% of the time it's going to be a member of the council who's appointed. The only time it's going to be someone else is if it's a small local council who cannot deliver that service in-house and may bring someone in. If they bring that person in, they are operating as a member of staff. So they're basically contracting them in to operate for the council, they're acting for the council. And as such, the appeal still needs to be supported by the council, just like they would their own assessment manager, because they are there to support the panel and undertake assessments. Now you might need to get specific legal advice on this, because I'm not a lawyer, although no change of career for me. But it's got to be a pretty rare case that this sort of comes up, and if councils are concerned about it, or private practitioners who want to undertake that role, I suggest you get your own legal advice on what that means for you. But we're talking about a pretty rare case.
But I think mine was a pretty simplistic question in relation to your answer, because I'm just asking that if there is an appeal by a proponent, let's say, forget about the other applications, which they can't be assessed by assessment managers, but if the proponent is against one or two of the conditions, for example, where does that put the external assessment manager in the role associated with
my guess,
the
not
origin?
being a lawyer, would be I'm working for a council. They've appointed me to be their assessment manager. I'm paid to do that assessment work. If it goes to appeal, I suspect the council would have to pay me for my time to undertake that appeal process. That is where I would assume, and you could put that in your contract if you were worried in working with the council, that is how it would roll, that they would then support any appeal processes should they arise. Imagine that's partly a contractual matter that you could work through if you were to be appointed at that function. But like I said, I'm not a lawyer, and you should get your own legal advice if you are concerned about that.
Thank you.
All right, we've got time for one more question. Sorry.
There's one over there.
I just have a question in relation to, particularly for metropolitan councils that will be operating under their existing development plans and the existing Development Act for another sort of 14 months or so. If they're in a situation where they've undertaken some strategic policy work and they're ready to submit their statement of intent and undertake a development plan amendment, is there any potential opportunity, I guess, for an alternative pathway that might straddle the two legislation, or for them to mimic either the existing consultation program or the new consultation program under the new Act, to ensure that their new policy that they've already consulted on, will make it into the code, or do they simply have to wait until next year?
So the way this works is, on the date that the code comes into play, development plans die. They no longer exist, which technically means that a development plan amendment dies and doesn't exist. Except, so you can pile them up and whatever. Except we have drafted transitional provisions that allow them to live on for another 3 months. So ones that haven't been approved but are completed, have run their statutory consultation process, have been honest with their community, and that's important, and that's a requirement that we're putting in when we're working with people now, that it is likely to be a transition to the code. The policy content is largely tried to mirror the code as far as practical, given the stage that the code is at. Then we will be able to, the Commission can consider that and then approve and recommend to the Minister that it be approved after the designated day. But after that, you technically they die. So, but the thing to be clear about is, under the Community Engagement Charter, if you've been consulting with the community for a period of time before the code is actually in on a strategic framework and policy outcomes, that still counts as engagement for the purposes of a rezoning exercise. So that might mean that you do a lesser consultation when you actually do your formal code amendment, because you get credit, if you like, for what you've done before. So no consultation that you do is wasted. It still becomes part of your community engagement plan under the Community Engagement Charter, and you can retrospectively consider those things that you've already done. So I know it is a bit of a hard and fast rule, and there was only a reasonable period that you can stretch out saying it's still alive. And the reason for that, it gets very confusing to the community if you've still got a live thing hanging over here that doesn't look anything like what it's going to transition into. So the short answer is, if you're in the regions now, you're pretty close to the cut-off point to be able to do anything. So I'd say if you haven't got a statement of intent in with us and you're in the regions in the next 4 weeks, hold it and just do consultation with the community on your strategic vision and the policy intent, and not on content, actual wording content. If you're in the metro, you've probably still got time to do smaller specific DPAs. Please don't come in with me like a residential DPA that does the whole of your council area or something like that. But if it does have an economic drive or important social outcome that you're trying to deliver, we're not going to stand in the way of trying to make those happen, and we'll try and push them through as quickly as we can. But if they're trying to do too much, we all know that as soon as a DPA gets too big, it takes forever. So keep them small. You're better to do 2 and split them and do 2 smaller ones than one big massive. Not that I'm up for doing lots of DPAs, but you know, the massive ones do take a long time. So try and just be sensible about what you can deliver in the time frame.
Look, Kim has had to step away, so I'm sort of taking over to conclude this afternoon's sort of proceedings. We do have a number of questions that were online. We probably don't have time to address a lot of those, so we'll probably take them on notice. And I suspect that a lot of you in the room probably still have some burning questions and things that you would like to perhaps get clarification on. So again, I think I'm just sort of conscious of time, so we can finish on time this evening to perhaps put them in writing, a bit of an email, and we'll perhaps disseminate that out to those that are here and actually online as well. So just a couple of things. PIA will be hosting a number of different forums like this, probably with DIPTI and getting others involved. So myself and Jodie, who's at the back, keen to hear from those in the room and those that are online potentially about how PIA can support as we transition into this new system. Will you please thank me in joining our panel and speakers today, so Anita, Kate, Chris and obviously Kim, who's had to leave, so thank you for your time. Just a couple other things I'd sort of want to take this opportunity to promote. On the 27th of May we'll be launching the PIA Awards for Planning Excellence for this year. I really encourage you to think about the sorts of projects that might be worthy of nomination, and certainly the people as well. We're always looking for Planner of the Year and Young Planner of the Year. It's a good way if you do have more of those sort of emerging professionals within your organisations to nominate them for Young Planner of the Year. There'll be information that is on the website and a number of EDMs that will be coming out, but again please feel free to approach myself or Jodie to get more information on that. And just also a plug, we've got our National Planning Congress, that's in a fortnight's time on the Gold Coast. I really encourage you to think about perhaps attending that. There's a lot of great, something in it for everyone, talking about sort of e-planning reform and a number of key issues as well. So again, if you would like to find out more information, please come and have a chat to myself or even and David as well. So I think we'll sort of conclude and leave things there for this afternoon. But again, if you do have some questions that weren't addressed in this afternoon's forum, please either put them in writing to us and we'll forward them on, or certainly contact DIPTI through their, I think DIPTI at the usual sort of online email. So thank you everyone for attending.